Okay, Jim, I can see your screen now. I think we're good to go. So we've got Jim Wright from the Utah Office of the Property Rights Ombudsman to talk to us about roads.
Great, thanks, Jason. As always, certainly appreciate the invitation to come here and to discuss various land use issues, and certainly appreciate the trust for the invitation, and I'm happy today to talk about roads. And as always, our hope is that we're going to be talking about things that will be useful to you. Certainly we're going to be addressing items that we see come through our office more often. And of course, I know that we're not going to be able to hit every issue out there or answer all of your questions necessarily with my prepared presentation. But as Jason mentioned, happy to take questions during the presentation. I can't read the questions from here, but Jason will let me know when there are some. At the end, we can do some question and answer if you'd like. And also, what we've done certainly plenty of times in the past is people have called up after one of these presentations, and we've had more specific conversations about the detailed issues that you are facing in your own jurisdictions. So just want to make sure that I'm clear that we're certainly not bound by what the presentation is, and we're always happy to discuss these issues on your time frame as well if that would be more helpful. So with that, let me get, there we go. We'll go ahead and I'll explain more what the specific presentation today will go over. So we're going to talk about roads by use and then abandonment of roads more specifically today. And the reason being is we have had a lot of these types of issues coming through the office, and it seemed like while roads as a topic is certainly very broad, and there are certainly eminent domain implications with roads, as well as exaction issues with roads, those are some of the other main issues that we see come through our office with roads. Those topics in and of themselves are whole separate presentations, and we've already even done exactions and eminent domain here at the Trust, so those presentations are available. But again, we're always happy to talk or answer questions on those topics as well. I just didn't want to rehash what we'd already done here in the past. So roads by use, we'll go ahead and talk about them more generally, go over how they arise, and then one of the biggest issues we see with roads by use is a question of width. How do you know how wide a road that has arisen under Utah's road by use statute is? And then with abandonment, we'll go ahead and talk about the requirements to abandon a road, and then what happens to the underlying property once a road is abandoned. That certainly has caused some confusion at times as well, we've seen. So we'll go ahead and go over that, with the hope being, of course, that you'll find something useful here today. I just love that picture. Anyway, we'll go ahead and leave it though. Okay, roads by use. To start us off on this, Ralph Waldo Emerson, it turns out, had a pretty good feel for roads by use in Utah. Who knew? He says in one of these quotes that obviously I've adapted from its original meaning, but do not follow where the path may lead. Go instead where there is no path and leave a trail. That's not a bad way to start the discussion of roads by use. Okay. So roads by use, it's a public right-of-way that arises under Utah statute. And so the statute there is in Utah Code 72-5-104. And that's the statute that governs road by use here in Utah. And this happens, the roads arise, the public right-of-way arises after 10 years of continuous public use. And this happens without any payment to the private property owner who owns that underlying property. And of course, we all know that the United States Constitution, as well as the Utah Constitution, requires just compensation when private property is taken for public purposes. This statute, though, is an exception to that general principle, where if the terms of the statute are followed, then the private property will end up being transferred over to the public without payment. And that's a key distinction from most everything else we talk about, in terms of transferring private property rights to the public. And so, for the public policy reasons for this, these types of roads arose back in the territorial times. When Utah was getting started, there was lots of development, there weren't a lot of roads, and people ended up, going ahead and, creating roads because it was the best way to get somewhere, to access mines or, other resources, farming, or just to develop the layout of various municipalities and communities. And the reason this came about was to encourage economic and resource development, as well as the highest and best use of land. And so, it made a lot of sense back then to have something like this, just as things were getting going, and to make sure that people had access to the various areas that they needed. Okay. So today I'll go over some of the issues we see with roads by use, and some of these we'll go ahead and address more in depth later on, and some we won't. But what we see a lot through our office is that a lot of times now roads by use are related to recreation, particularly ATV use and other recreational trails. And oftentimes these trails will be crisscrossing private land in sort of a webbed pattern, or without really going to any specific point. They just go around, and the public's used them for over 10 years, and we get property owners calling us up and are really frustrated by this. And we just have to walk them through what the statute says and what their options may be, which basically are convincing the jurisdiction that they want to abandon the road, assuming that the road has already been established by use. So there are also some issues with the requirements to prevent the establishment of a road by use. Just real briefly here, and we'll get into this a little bit later, but the Utah Supreme Court a few years ago had a couple of cases that some of you are probably very familiar with. Oakleberry being perhaps the most famous, but Prisbury is another one that was decided on the same day, where they had to decide what does it mean, and how would you stop continuous use under the statute? Because back then there weren't these specific requirements to prevent the establishment of the road in the statute that we'll talk about here in a little bit. But the Supreme Court basically said, look, whenever someone takes an intentional action that to block access to a road, and so long as that action is reasonably calculated to block the access to the road, then the 10-year time period will end up will stop, and they'll have to start that new 10-year time period after each one of these actions. And so this is sometimes the BYU rule, where BYU would go ahead and take action to block their roads there on campus to make sure that they did not end up becoming public roads, the road that rings the campus there. But after these cases, the legislature decided it did not like how the Utah Supreme Court ended up coming to a resolution of what the legislative intent was around continuous use. And so, like I said, we'll get into what the legislature did and the specific requirements now to prevent the establishment of a road. But that's certainly one that we see quite a bit. Road width, as I mentioned before, this is one that we're going to go more in depth on as well. It's, with the mediations we do, we certainly see this quite often when we're mediating an eminent domain or condemnation matter. Sometimes there's an issue of having to determine how wide the road is because it's a road by use, and the jurisdiction needs to widen that road, and that's sometimes one of the issues we have to deal with in the mediation, so that everyone can agree and move forward, and property owners can get their just compensation, and the jurisdiction can go ahead and get their project done that's needed for the public benefit. And with these, a lot of times we'll get ownership to the center line of the road. A lot of road by use situations, people will have record title to the center of the road, but the road has clearly been there for over 10 years. And so we get calls like this all the time, and we explain to people that you can't stop the road, you can't tear up the road. The road has a right to be there. It exists, and there's a public right-of-way that that's going to continue there, and you aren't entitled to payment. Yeah. Oh, great. Yes, my short answer is to this question, which is, does a government entity have the right to install utilities in a public road that is established by 10 years of continuous use? My short answer to that is yes. There's a case law that suggests that is the case. I would say on this one, though, I don't have it right in front of me, but give me a call or shoot me an email, and I can get you some more specifics on that one. But the short answer on that one is typically yes. Thanks for that question. And that was big enough I could read it. Thanks, Jason. Okay, so a lot of times and again, don't hesitate to ask questions anytime. I'm happy to take them. And so with these people that call in, having this issue with owning record title to the center of the road, we explain that they own some reversionary underlying interest in the property, and if the road were ever to be abandoned, they would then take title to the property back to the edge of their record title. But most of the time, those roads probably won't be abandoned, and in the interim, they're paying oftentimes taxes on this property. And so what we typically tell people to do is, call up the assessor's office and say, why are you taxing me to the center of the road, and save themselves a few bucks every year by having their assessments altered to reflect the reality that they're being assessed for what is a road, a public road. Then the RS-2477 roads, that's certainly been a big deal here in Utah and out west. This, just briefly, because this deals with federal land and it's outside of the jurisdiction of our office, but it is an issue I want to make sure that I briefly did touch on it. RS-2477 was a federal law that existed until 1976, and this law provided for a way for public roads to arise over federal lands. And so basically what's happening now is there's litigation over whether or not certain trails or roads were legally established before 1976 when this law was repealed by Congress. And so the state of Utah certainly has been in lots of litigation over this, and there's a whole group at the Attorney General's office that deals with, Utah Attorney General's office, that deals with this issue. So again, it's not something that our office deals with. We don't have that jurisdiction, but it is a road issue that I wanted to at least mention. Okay. So let's go ahead and walk through some of the key points of the road by use statute in Utah and go over what it says and requires. So for a road to be dedicated under Utah law, it requires these three things. First is continuous use. Then second, by the public as a thoroughfare. And then third, for a period of 10 years. So those are the requirements. Now, continuous use, the statute tells us, may be seasonal or follow some other pattern. So this is not the case where you need to have people on a road every day, 365, to have a road established. Sometimes people will only use a road in the summer. Sometimes they will only use it in the winter. And so courts have made a distinction between an intermission in use and an interruption in use. So an intermission is simply when the public doesn't feel the need to use it, and so they're only going to use it in a seasonal manner. And so, that's an important distinction to keep in mind. Interruption, which will stop the 10-year period and make it restart because someone has actually physically stopped people from using the road, and we'll get more into that here in a second, versus the intermission. Okay. So continuous use is only interrupted here under the statute by these two ways. When the regularly established use has actually been interrupted for over 24 hours, or by a barricade when the person setting up the barricade, and this is important, gives at least 72 hours advance notice to the jurisdiction having jurisdiction over the road, and the barricade is in place for over 24 hours. Now, there's been a recent change to the legislation. Previously, it required a manned barricade. Now it's just a requirement to have a barricade there. But this is the specific change to the law that I was mentioning that happened by the legislature after the Oakleberry and Prisbury cases, that line of cases right there. The legislature came back and said, no, we don't like your way of stopping continuous use. This is how we want to do it. There's not going to be an action that was intended to stop use and was reasonably calculated to do so. You've either got to actually interrupt it for over 24 hours, or you can use the safe harbor by barricade. And really, I mean, the only, the barricade is typically how people are going to go about doing this, just so they know for sure. And there's some problems with the barricade approach that many in the property rights community see. And that relates to the fact that, we'll go ahead and get to this next slide here because this addresses it, but if the highway authority demands that the interruptions stop and the property owner accedes to the demand, then there was no interruption. And so typically jurisdictions that have authority over roads also have some sort of law enforcement arm. And so what happens, or can happen, is someone will give notice to the jurisdiction 72 hours in advance, say, hey, we're going to be going ahead and blocking off this thoroughfare because we don't want it to go 10 years and then have a public right-of-way arise. Well, if the sheriff shows up and says, hey, you need to remove this right now or I'm going to arrest you, there's sort of there's an issue there with being able to prevent a road from becoming public property, even though the owner is trying to do so. And so that's an issue, again, that there's certainly folks who are very concerned about and its implication on property rights, because this is before the road has become public property, or before there's a public right. It's private property, and yet you can have situations where governments can step in and potentially stop people from protecting their private property rights. So we see this as an area that is ripe for some future legislation, to make sure that there's a workable solution to both balancing the public's needs for roads as well as protecting the private property interests of the private property owners, as the constitutions require. So just be aware of that issue there. Now, it's also, I would point out, unclear exactly what accedes to the demand is. It's not clear if that means that the private property owner said, okay, I'll go ahead and remove the barrier, or if they say, I'm not going to remove it, Sheriff, but I won't stop you from removing it if you want to, or if they really have to actually be subject to arrest or not to not accede to the demand. But anyway, that's some highlights there of the issues with preventing the road from becoming public.
Okay, I've got a question on this.
Yeah.
Rob says, I might have missed this. No notice to highway authority equals no interruption, right?
Right. I'll go back here. So that's so there's an A and a B there for continuous use being interrupted. So you can either actually interrupt it for a period of over 24 hours under A. Again, there's going to be potentially some evidentiary problems if this gets into litigation. But you have to be out there and you have to actually interrupt it, stop people for a period of over 24 hours. So the hard part there is potentially if it's seasonal, were you there during a period of intermission? And is that going to count for the time period when this was established, when the road's established, because it was established based on a seasonal use? So there are some concerns there that people have in being able to actually 100% sure stop the use, the continuous use. Now, for the second part there, the B, for the barricade, yes, you have to give 72 hours advance notice to the jurisdiction before you set up the barricade. So that does have to happen for you to have the benefit of that safe harbor rule.
Okay, we've got another clarification on that.
Sure. Yeah.
Let's see. Kevin asks, when you say the highway authority, Does this mean UDOT or the city/county where the road is located? Obviously, it's not yet owned by UDOT or the city/county, so this seems ambiguous.
Right. And so typically it's going to be the county or the city, because since you have correctly noticed, there is not yet it's not yet a public road, so it's not actually monitored or maintained, et cetera, by the entity. However, if there is a road in unincorporated county areas, it's highly unlikely that UDOT would ever have, that would be a state road, for example. Now, there are state roads that have arisen by road by use. Some areas of, for example, Redwood Road, road by use. But, as you do point out, those have already been established as rights of way. So this is almost always going to refer to the municipality or the county, depending on the specific location. So,
okay.
If you're within city limits, you're going to give notice to the city. If you're within the unincorporated county, you're going to give notice to the county. And most often at this point, these are trails and roads that are that are crossing more rural area. Doesn't happen so often now, where they're still arising in highly developed areas. But yeah, that's a great question. And if you have any follow up on that, let me know. I'm happy to keep discussing it. But
thank you.
Mm-hmm. Okay. So the width now. Let's get to this width question that I mentioned. The statute here, and I pulled out the relevant language, says that the width is that which is reasonable and necessary to ensure safe travel according to the facts and circumstances. So definitely not the most bright line of rules that you're ever going to find in a statute. And it's no surprise, given this language, that there is disagreement over how wide these roads by use are. And so, of course, because of this, there's been a fair number of cases in Utah that have tried to give more, clarification on principles and how this can be established. So let's go ahead and talk about some of these here. First off, there's a question about who actually gets to determine how wide a road by use is. Excuse me. So previously there was some misunderstanding in thinking that the local jurisdiction, so the city or the county, would be able to go ahead and determine this. And there's clear indication from Utah cases now that that's not the case. It's the district court. The district court has jurisdiction to decide how wide one of these roads is. And I see here that we have a question here I'd like to address. So does this statute only apply to privately owned land, or can it also apply to state or federally owned land? Great question, and I appreciate this clarification. So this statute only applies to privately owned land. Now, I say that with the following caveat, and that is, under the RS 2477 roads, if a road would have been established by use on federal land before 1976, then it could also apply to the federal lands. And this is what all this litigation is about right now with the RS 2477 roads. But as far as going forward, no, this cannot apply to federal or state lands. This follows the general principle that governments don't lose their lands by use of others. So it's it's not the same thing exactly as a prescriptive easement or adverse possession, but it's a similar principle. And governments aren't going to be losing their lands with a road by use, state, federal, or local. It's just against public policy. So yeah, thank you for that question. So no, we're talking about private lands here. The statute is private lands. except, as I mentioned, for the RS 2477 situation that, to the extent it arose before 1976. Thank you. And please do continue any of these clarifications. I'm certainly not going to pretend that I nailed all of this and set the groundwork such that it's clear to everyone what I'm talking about here. So thank you for these questions. So sometimes we will see on trying to determine the width, a jurisdiction will come in and say, well, we have a statute in our jurisdiction that says that all roads are 66 feet. And so therefore, any road by use is going to be 66 feet. And, courts have certainly looked at this, and their response is, no, just because you have a statute or excuse me, a local ordinance that determines how wide your roads are, that does not necessarily mean that every road by use is going to be that wide. However, the courts have said that it can be used as evidence for determining the width of the road. Say, for example, there really was a reason that the jurisdiction needed to have 66-foot wide roads for the safety of the public, then that's certainly something that the court would take into consideration, but it will not be determinative of the issue of how wide the road is. And by the way, let me interject here that I've left here as I've gone through citations both to the Utah statutes as well as giving you some case law. I'm not trying to, this is definitely not meant to be a treatise exposition on this subject. We could certainly go much more in depth on any one of these topics than I am. But, I didn't want to turn this into overwhelming list of citations. The flip side is I wanted you to be able to have some authority for things I was saying so that in case you saw what I was saying, you're like, well, that's great that he said that, but where did he get that from? You had at least some citations that would help you as you were dealing with whatever issue related to the citation given. And so, I offer that hopefully to be helpful and not to be certainly annoying or overwhelming. So, but I find it helpful when people will give the citations as to their points so that you can go back and double check things and use them to hopefully help resolve disputes as well as decide internally how you're going to approach a matter, with your counsel so that, you can avoid litigation but at the same time be protecting the rights of the public and private property owners. So enough of that interjection. So now a recent case that came down here, the Clearwater Farms LLC, this came out just a couple months ago, very, very recent. This case addressed the issue of whether or not a court needed to take into account the future use of the road or whether it could only look at the past use of the road during the time that the road would have arisen. And the court said that you do not take into account the future use of the road in determining how wide it is. So it's not hard to imagine situations where a road by use arises and it may go someplace that will have lots of future development later on, necessitating a much wider road at some point in the future. And the court specifically said, no, you can't use that as a basis for determining how wide the road is going to be. You've got to look at what's happened in the past when this arose. And so, that's certainly a helpful and important case, making that clear. Okay, so there are lots of other factors that go into trying to determine how wide a road is and getting some sort of framework for determining what in the world is, what is the width that's reasonable and necessary based on the facts and circumstances for safe travel. That's pretty, as I mentioned before, pretty ambiguous. But this Hunsaker case also gives some other factors. Again, none of them are necessarily determinative, and that's what makes this such a difficult topic, is it's hard to know before trial exactly how wide a road will be deemed to be by a judge. But this certainly does give some factors and some helpful guidance on this topic. And so things such as fence lines, so if there are fences that are all in a row that are 60 feet across the road or 66 feet across the road and they're all in a line down a certain road, and then they match where the road ends up becoming a deeded road or a condemned road or a dedicated road, and it flows seamlessly from there onto this road by use, that's going to be some decent evidence that the road, was 66 feet wide. And that also ties into this idea of the usual widths of the street in the area. So again, if all the other streets are 66 feet wide and this connects to them, that's also evidence. Again, none of these are determinative, but it's certainly evidence as to how wide the road should be. If jurisdictions end up plowing the roads and leaving snow in a certain area, or there are utilities that the jurisdiction has had there and run down a certain part of the road, sidewalks and shoulders, all of these things provide evidence as to how wide a road will be. But again, this is an area that has lots of case law. It can be certainly contentious. What I will put in here as my practical application plug is when we mediate these types of things, it's helpful to have these cases and these principles as a backdrop. But this is really a great thing to go ahead and just get resolved through mediation or even in direct negotiations with property owners. Litigation gets very expensive for both parties and is really in neither party's interest. And oftentimes there's enough evidence that people can come up with a solution that both sides can feel reasonably comfortable with agreeing to. And so the vast majority of these kinds of cases that come through our office, we end up resolving through mediation as part of the eminent domain mediation or whatever other mediation it is that we're doing, or we could even do it, as a standalone, given that it does implicate potential takings without just compensation if the government is claiming a wider road than it has the right to claim. But so I offer that to you as a practical point and an invitation as well that if the property owners would like, we are always available to, one, answer questions, and two, to go ahead and mediate these to try to get them resolved for everyone, so that again we avoid litigation. That's sort of a backdrop to a lot of the conversation and a lot of what we do in the office, and hopefully many of you have had the chance to work with us and to use us if your property owner is so desired, to try to get these kinds of disputes resolved in a fair way for everyone. So anyway, that's a little talk for the office as well. Okay. Let's go ahead and switch gears here a little bit and talk about the second main topic that I mentioned we would be addressing today, and that is the topic of road abandonment. And this I like this picture as well, and it really is surprisingly relevant to this case, Harvey Real Estate, that I'll describe here, that gives a very important point, along with this statute that I cite here, this Utah Code 72-5-105, and that is you must have formal abandonment of a road. Non-use of a road is not sufficient to abandon a road. Okay, so let's get to the specific case here, this Harvey Real Estate. So on Highway 89, many decades ago, UDOT, or UDOT's predecessor, ended up getting an easement over some private property for part of Highway 89. And for a while, it actually used that easement for its Highway 89 purposes. At some point, the private property owner ended up fencing this area and actually grazing livestock over this road area that had previously been used for a road and was legally a road based on an easement held by the State Road Commission. And so they were grazing it for 50 years. I mean, these cows are out there for 50 years. UDOT ended up coming back and saying in the 90s, hey, we need to go ahead now and move your fence and displace your cows a little bit here because we need to expand Highway 89. And the property owner said, hey, look, guys, okay, if you need to do that, that's fine, but you're going to pay us for it because we've been using this property and you guys have abandoned the road. The court said, no, you cannot abandon a road through non-use. You can graze your cattle there all you want. It can be for 50 years, which you were. It could be for 100 years. It's not going to go away. And so That's an important first point. Now, having said that, that's, obviously you need to look at your specific situations, and I know that sometimes jurisdictions have felt that it would be fair to give some amount of compensation to a private property owner, depending on the specific circumstances of the case. In a situation where there was a legal right to have a road in a way that would be encroaching on area that the private property owner had been using as if it were their private property. But I just want to make sure that the actual law is understood, and that is you can't abandon a road through non-use or through the use of an adjacent owner, using it as if it were their property. That does not necessarily mean, though, in your specific situations, that you would never entertain some kind of mediated or negotiated settlement on that issue. But that's the law, both in the Supreme Court case, the Utah Supreme Court case that I mentioned, Harvey Real Estate, as well as the statute. Okay, so it's important also to understand that the determination to abandon a road is a legislative function in Utah. So the legislative body of the jurisdiction is going to, is going to decide that. With that, though, there are certainly some applicable laws, and it's important, again, maybe just a quick reminder here, for a legislative action to be legal in Utah, it cannot be arbitrary, capricious, or illegal. And so in order not to be arbitrary and capricious, it just has to be reasonably debatable that it's in the public interest. That's a very low standard. And of course, not to be illegal, it just has to comply with all of the laws on the books relating to the particular action at issue. And in this case, for municipalities as well as counties, the Land Use and Development Management Act has basically identical provisions in each one of those areas detailing how you go about vacating a road. And so one of the requirements is that the legislative body find that good cause exists and also finds that no material harm to the public interest will happen or to any person. And so, if you've got a public road and it's this public road that is the only access to public roads that some property owners have, you're going to have a hard time showing that there is no harm to any person. Now, I don't want to get too far off into the weeds here, but there's other cases that show that even if you were to abandon a road like that, they would still maintain a private easement. But even with the private easement, they can still be harmed if there's not a way to directly access public roads that they used to have. So just keep that in mind as you're looking about abandoning roads. And sometimes there's really great reason to abandon roads. There's other ways to get to the same spot. There's no reason for the jurisdiction to be maintaining a road. It would just be, the property owners that abut the road would prefer that the road be abandoned. So there's certainly plenty of times when it makes sense. Let's go ahead and talk now. And by the way, I'm jumping over a whole bunch of the statute, just not only for time's sake, but I'm trying not to be too boring here. But that is in the statute, and I reference it. You have certain notice provisions you have to do, and there are other things that have to happen, but that's laid out in the statute. Pretty straightforward and uncontroversial as far as our experience has been. So I didn't want to spend a whole lot of time on that, but do know that they are there, and take a look if this is an issue that you're going to be dealing with in your jurisdiction. An issue that we do see more questions with, and is not necessarily quite as clear, is the question of the status of the underlying property of the road once the road is abandoned. And I'll put a little plug in here. Our office, Jordan Colomore, an attorney in our office, just wrote an advisory opinion. It's advisory opinion number 166, and it deals with a question relating to the abandonment of a road involving Les Olson Company in South Salt Lake City. And so, I'll refer that it talks about some of these and gives more depth on some of the law relating to the abandonment of the road. And if it's an issue that you're looking at, and the status of the underlying property as well. That would probably be a helpful reference for you to take a look at, and it can be found on our website, and it's propertyrights.utah.gov, and on this next slide here, our website will be up as well as our other contact information, so you'll have that. And any one of us would be happy to talk to you about that, and Jordan specifically would. So, if this is an issue you're having, take a look at that on our website. You can get it again, as well as give us a call. So, end plug. Okay, so now the status of the underlying property. Really, in order to give an answer and to know what the status is and where the property goes when you abandon the road, you have to know how title to the road was held. And that's going to be determined by how it was, how it arose and how it was either deeded, dedicated, or arose by statute. And so, when the government has a fee simple determinable interest in the property, and I'll explain what that means here in a second, the adjoining owners take title to the road, to the center of the road that adjoins their respective properties. So what's this fee simple determinable? Basically, that's a fancy real estate legal term that means that you own title to some property so long as it is used for a particular purpose, so in this case for a road. And once that purpose ceases, so you've abandoned the road, then the property reverts. And so the way this happens, practically speaking, in Utah most of the time is when roads are dedicated on a plat. So plat dedications, Utah case law has confirmed, are determinable interests. And so when they end up being abandoned, if that happens, then we know what happens based on both case law there that I've given you, as well as the statute there, the 72.5.105. And so that, that's helpful to take a look at, just to confirm what I'm telling you. But know that, plats are fee simple determinables when to the extent that the road was dedicated on a plat. It's also possible to have roads deeded in a fee simple determinable. So, for example, the language would be, hey, I go ahead and grant to municipality or county for so long as used as a road, the following described property. Some language of that nature where it's clear that it was given for a specific purpose. Okay. So that's what happens there. Now, if the government has an easement, then the record owners, and by record owners I mean the people that have record title to the underlying property. Oftentimes this will be to the center of the road, but sometimes it will be some other portion of it. These property owners will take full title back to the extent of their record interest. So this can happen, like I said, for easements, and this is what happens in a road by use. Because there is still an underlying record interest that stays with the property owner who has a road by use going over his or her or their property. And so, they still maintained a property interest. It just wasn't really worth anything. And by the way, I should interject here as well that case law and treatises suggest that this reversionary interest it is a legal right, but it doesn't have much value. But just keep in mind that it is still a legal right they have. But so anyway, when a road by use gets abandoned, then the property reverts to the underlying owner. Or if there was an easement, or if people have record ownership to the center line of the road, again, whatever area they owned, they now own free and clear from that easement or right of way. Okay.
Jim, on that, would there need to be a process like a quit claim from the governmental entity or something to transfer that or to get back to?
So in the abandonment for the municipalities and counties, in that statute that I mentioned that I was going to skip most of, they have a process there where you either need to get an ordinance or you can go ahead and take other action, but it's in the statute there. Most often what happens is there's an ordinance and it gets recorded, and therefore, that's how it's taken care of with title.
Great.
Yeah, thanks for that question. So now here's the question where the government retains title. So if the government owned the property in fee simple absolute, which is a fancy way of saying that there was no record owner other than the government under the land, someone deeded the land to the government and they said, you know what, let's go ahead and put a road over this part of it. Or someone deeded it without restrictions for a road, or through eminent domain, where you end up getting fee title to the property. Okay, when that happens and the government abandons it, then and there's a little caveat here I've got to give as well, but typically under case law and under Utah law, you're going to own that property free and clear, and I'll get to one exception and one potential exception on this in a second. And then, pursuant to the normal laws of Utah, you would need to dispose of that property in a way that is in the public's best interest, which most often means you sell it for money, and depending on the particular statute and in your particular situation. But you would have the ability then to monetize that road. Now, one potential exception that I mentioned here, if it was acquired by eminent domain, then a right of first refusal most likely will apply to the original grantor. So check that statute, check how it was acquired, and you may need, before you sell that, you may need to give a right of first refusal to purchase that property to the person, the original grantor of that property, when it was condemned. Now, this statute here that I mentioned earlier, the 72-5-105, it has language that may suggest that in every case, the road will then be given back to either the center line of the road or to the record owner, to the extent there are record owners. I think that you can read it in a way that is consistent with Utah's case law, with the common law of Utah, that when a government owns the underlying fee interest in the road, that they then need to go ahead and sell it or make use of it for the benefit of the public. But I just want to point out that there are some who read that statute and say, you know what, until a court has a case on this and tells us for sure, we can't be 100% sure that we don't need to have the road go to the center line in every case. My personal view is that, given the body of common law and case law, as well as the fact that it's possible to read the statute in a way that is consistent with that law, means that you would go ahead and dispose of this property that either the city or county owns in the way that you would normally do for the benefit of the public. But I just want to at least point that out, that there are some who have at least a pause at that interpretation. Great. I've been talking here for a long time. I appreciate everybody that has been able to make it through all this. I like these pictures with nice green foliage. It, a little better than just looking at a blank screen here. Let me go ahead and get to the last slide here. I know there's some questions, and so I'll go ahead and address those. And if you have any other questions, please do let me know. Like I said, if you prefer just to call me up or call up another attorney in the office, we'd be more than happy to discuss this with you and do whatever we can to be helpful. So here's our contact information to the extent you don't have it already, and certainly appreciate your time here today. And I'll go ahead and look at some of the questions I've got and any other questions that come in. So thank you. So let's see. So here's a question. We have many roads that are plus or minus 18 feet wide. In order to make 2 lanes of safe travel, we try to widen them to 24 feet, 2 10-foot travel lanes and 2-foot shoulders. Then we shift drainage back too. Is this beyond what is potentially allowed on road by use? Great question. And here's some guidance on this one. If when the road by use, looking at its historic use, and based on all the factors that I mentioned there previously on the previous slide, if the road really was only 18 feet wide, then in order to, in case let's say this, if you want to expand beyond that, then you need to go ahead and either get the property owners to convey the property or condemn it. Now, it's conceivable that there's a situation where for a period of at least 10 years, people are driving on the shoulders, for example, and using a wider area than was originally there, continuously for that at least 10-year period, and then, the bounds, could have been pushed out. But as a general rule, if you are expanding a road by use in Utah, you must pay for it. It's something you can condemn for, You can do that, but you need to follow all of the legal procedures and processes to condemn the property, including the payment of just compensation to the appropriate owners. So just because a road by use exists and facts have changed doesn't mean you can go ahead and widen it. And again, as I mentioned, there is case law on that you're going to need to pay for that, typically. What's hard about this is it's hard to give bright line answers that apply to every situation because, as I mentioned, there could be a situation where people have just, for over 10 years, used a bigger area, in which case maybe you're okay. But that's the general principles there that I've enumerated. And again, happy to talk about this further. If you'd like to give us a call, we can go over it, if you want. So I have the same question as Josh about the drainage. Could the width include drainage ditches on the sides of the road and the right to install and maintain drainage ditches? The answer is yes, potentially it could. Say, for example, if during for a period of over 10 years, you've had drainage ditches and those have been there and it's necessary for the safety of the public. Of course, roads that drain well are safer roads, and you have been in there and you've been maintaining them for a period of over 10 years, then, I think that based on that fact pattern, it would be likely that that would be included in the width of your road. The issue comes is if you did not have the drainage there, you have this road that's established by use, and you want to go out and expand the road by 10 feet further into the adjacent property owners, and you say, well, it's for safety, but you're not going to go pay the property owners for their property. That would be more problematic. But assuming that the drainage ditches were there and that they'd been used and it was necessary for the safety of the road, then yeah, if they've been there for over 10 years, then very, very likely I think that they would be part of the road. So.
All right. I've got let's see. I've got another question here regarding public, the general public versus the authority. So we have the general public wants to access this place, and they've been going across this road for 10 years, but the authority has no interest. They don't want to take that on.
Okay. Well, if the public has been using it for over 10 years, then under Utah statute, a road has arisen. Now, that does not mean, though, that the authority cannot say, we have no interest in this road and we are abandoning the road, and go through the process to abandon the road. And the assumption would be that the private property owner would want to stop people from using the road, and therefore, if the jurisdiction is able to go through the requirements to abandon the road, the legal requirements, and abandon the road, that the private property owner would then put up gates or barricades or stop the public from any future use of the road. That's fine. You can go ahead and abandon it and have the private property owner stop people from using it. Put up gates, barricades, whatever it is, stop the public. And then it won't become another public road after another 10 years. But yes, we do see, and we personally have been involved in situations with private property owners as well as counties where they have said, you know what, we really don't want all these roads. They're a bunch of ATV trails. It's a hassle for us. There's no reason for these to be here, and we don't want any sort of, liability for them as public roads. We'll go ahead and abandon a lot of them. And in the specific case I'm thinking of, they needed access to a particular waterfront area, and they were able to work with the private property owner to get a better road just going down to the water and abandon all the other ATV trails that eventually made it down there but just really weren't helpful and necessary. And then again, the private property owner is going to want to be stopping the public from using the trails. But yeah, absolutely, you can abandon these for sure.
Great. We've got one other question here. In a private subdivision with private roads, as per recorded subdivision plat, and these roads have been open to public use, drive, visit property owners, etc., for over 10 years, having never been gated off for 24 hours, could these roads now be gated, or must they remain open?
Well, that's a great question. And one of the fun things about this road situation is you can have these fact patterns that get really interesting really fast. Now, if the public has made use of these roads for over 10 years and there's never been any gate or actual interruption of the public's use of these roads or barricade. This is the BYU rule, right? This is why BYU does this, where they have the gates that come down and say, nope, no one's coming through, we're taking this action, precisely so the situation you've mentioned that does not come to pass. Now, based on what you've explained, it's certainly very possible that those are now public roads. Having said that, jurisdictions can have some discretion. At the end of the day, you don't have to, if the private property owners are saying, no, these are still private, prove it, the jurisdiction does not necessarily be the one that has to go and litigate this. If you have no interest in it, then you'll say, well, maybe, but we have no interest in this. We're not going to litigate it. If the public generally, though, that wants to have access to these private roads feels strongly enough about it to litigate, and the court says, yes, it is a public road, then guess what? You've got a public road. Now, I do want to stress again, though, that you have the ability as a jurisdiction to go through the legal process to abandon public roads. And maybe this, and if this does arise and you don't want it, you could abandon it potentially. And then obviously this area, this private, this private subdivision with these roads would then do well to put up, at least periodically, an actual barricade, go through that safe harbor rule, because this is clearly a situation where you would not send the police force to tell them to put it down. You would actually perhaps even invite them or remind them to, put up the barricade. But yeah, that's there's some thoughts on that one.
Okay, thank you, Jim. I guess my mind goes down the road as a risk manager to the point of, on the same subdivision question. So say we have an unsafe condition on a road in a private subdivision that is, this similar situation, or is there potential that the city or county could incur some liability based on that unsafe condition, based on this doctrine of road by use?
Let me answer that this way. I would say I think there's a potential. You would have to have first, though, as a preliminary matter, you'd have to have it established as a public road, which, though, as I mentioned, that could be if someone wants to litigate it and take it all the way for a judicial determination that, yes, it is a public road. So I think, again, just looking practically at this, if you are in a jurisdiction where people do have roads that are private, that are not open, that you as a jurisdiction have no interest in acquiring, it may not be a bad idea. There's nothing stopping you from saying, hey guys, why don't you give us 72 hours notice and just put up a barricade for 24 hours? Put a gate there that, is going to require people to, stop where you can control access, and stop just the public generally. I mean, there's certainly a reason why most of these roads are gated. There's a variety of reasons, but this is certainly one of them. Now, there's also nothing stopping you from saying, hey guys, there's an issue here, take care of it.
Yeah.
But this does get into the risk management. It's a little gray area because it just depends on where exactly you are and if a court's going to find that this is in fact a public road. And so that's why better just to deal with it to the extent you can, obviously, with keeping it from becoming a public road, or just having, regardless of whether it is or isn't, just fix it. Having the private entity fix it.
Okay.
Because they're gonna, they're potentially at the same risk as the municipality or county, the governmental entity, on this one as well. So.
All right.
Less
well, we've kind of exhausted our time. I do have a couple more questions, and I think Jim would be okay to answer those, but
sure.
But we have exhausted our time. So if you do need to get off the webinar, that's fine. But let me hit there. There were a couple more questions that came in. Then, is there a way for a private property owner to give license to an undetermined class of people to cross a property in a designated location without the crossing becoming a public right-of-way and coming under the jurisdiction of the local government?
Well, I think there the key question is the public generally making use of that road in that area? And if the answer is yes, then if they're making general use of it for over 10 years, then without any interruption, then I think you have a public road. Based on Utah statute, there's not a specific, unlike a prescriptive easement in common law, the statute does not require non-permissive use. So if you give general permission to everybody, and everybody comes in there and uses it, and you do that for 10 years, I think you've got a problem if you are trying not to have a road established. So again, I'll come back to BYU just because they're a great example with what they do. There's a reason why they shut down the roads. They block them off periodically, just to make sure that, even though they've, as you mentioned, given a license to, those affiliated with the university or, people who want to come and do any sort of business there, they are making sure that this does not end up becoming a public road because they have not established that control. Again, if the public generally has used it for 10 years and there's not been this block, I think it's a public road.
Okay. One more question, then we'll wrap it up. Do the requirements of LUDMA for abandonment apply only to platted roads or to all roads, including roads by use?
Mm-hmm. I do not see a distinction in there that makes it only to platted roads. So that's, as far as I am concerned, the process that you have for abandoning a road. Of course, municipalities, particularly, most of the roads you're going to be dealing with will be platted, but not necessarily all of them. And that's the process under law to go ahead and vacate them. Okay.
Awesome. Thank you so much, Jim. That's been a great discussion today. Definitely will spur more questions. So make sure we've got Jim's contact information, the Ombudsman's office there. Make sure that you take advantage of their service there and the great knowledge that they have. We appreciate your attendance to the webinar. We did record the session, and we'll place that up on the webinars or on the website as soon as we can get that rendered and placed up there for your use. Thank you so much. I appreciate it. Last words?
Thanks. Appreciate everybody, and yeah, happy to keep the conversation going. Do what we can to help out.
Awesome. Thanks so much, folks.